To the extent then there are references to historical facts, that's also dealt with in this report, and those 7 or 6 other medical reports which have historically been tabled haven't been challenged in front of the Commission, and they stand as an explanation for those outings,
You see,
one way or another.
last time, and I will repeat even now, last time when you made a similar point about these reports not being challenged, I said to you, how do you expect them to be challenged when Mr. Carrim is resisting, strenuously so, to be examined by somebody who can actually challenge those reports? So it's a non-starter for you to talk about a lack of challenge.
That's
Complete non-starter.
I respectfully disagree with you for 3 reasons, and this is my third comment. In the first instance, the doctor has himself made himself available on more than one occasion to the Commission.
It's not the doctor that the Commission wants to have assessed. It's not the doctor.
Be that as it may, it's a less intrusive means that's available to the Commission in circumstances where the purpose of the examination is to run a parallel process to verify those clinical opinions. That's the purpose of getting the patient into a voluntary medical examination. The point I'm making is that the doctor...
I'll listen to the rest of your rebuttals, because you say you disagree with me, and I think you said on 3 bases.
Yes.
So the first one, I do not accept at all. You may continue arguing on it, or you may proceed to number 2 and number 3.
No, I won't. It's on the record, and that's sufficient for my purposes.
Okay.
The doctor's made himself available. Nobody's chosen to do anything about that.
Nobody wanted to assess the doctor. So
No, but
may I finish?
I apologize, Chair.
That's simply not an answer to my point.
With all due respect, though, I think we're speaking cross purposes, because what Chair is saying...
We are not. I understand you perfectly, and I'm sure that you too understand me. To counter the question whether Mr. Carrim is indeed unable to come to this commission, the Commission has said it wants to have him assessed by an independent specialist. He has refused that should be done. That's the assessment that the Commission wants to have. It's not an assessment of Mr. Carrim's specialist. That's a simple point I'm making.
Yes.
And for Mr. Carrim to offer us his specialist, that does not assist. In fact, that actually takes us to what courts always say, the hired gun principle. Because from where we are sitting, we do not consider Mr. Carrim's doctor to be an objective expert. He is an expert that's closely associated with Mr. Carrim, and who, from where we are sitting, unless we get another opinion, appears to us to be pushing Mr. Carrim's story. So very close to, if not analogous to, what courts have referred to as a hired gun. In this sense, if a court wants to get an objective view, it will want to get someone who is independent, as opposed to someone who's closely associated with the person concerned. And this is exactly what we have here. A medical specialist who has been treating Mr. Carrim for this lengthy period, and who on certain facts appears to have shifted the goalposts. And why do I say so? I say so on the basis of that paragraph that I referred to during the postponement application. In fact, I referred you to more than one. There are the paragraphs where he changes his story on factual issues, not issues related to Mr. Carrim's condition. On factual issues, he changes his story, because he said a patient can only go out of the facility, only, underline only, if I allow them to go out. But once we got the Woolworths and the Kauai visits, all of a sudden, the doctor now changes tack and says, oh no, actually, even nurses do allow patients out. So from where we are sitting, those are indications that this is a doctor who has so aligned himself with Mr. Carrim that sitting, I'm not saying he's lying. All I'm saying is, sitting where we are sitting, we just cannot accept what he says. We do want to have an independent assessment, which we do not have and which we will obviously never have, because this same doctor strenuously resists that. And it is best known to him why he does so. Of course, it does explain in the reports that he has given. But from where we are sitting, we cannot just accept that. So it is on that basis that I say, in accordance with jurisprudential authority, he is very much, his position is very much analogous to that of a hired gun. And it's in those instances that courts always insist on someone who is independent, someone who is objective. But as I say, we are not going to hold our breath on in that regard. We are not going to have such an independent assessment. So I say again to you, you cannot say that, you cannot respond to my point about the lack of contradiction in the manner in which you do, because that opportunity has been refused. I know I've said a lot, but respond anyhow you want to.
No, I'm indebted for the indulgence to respond. I am cautious, however, that I'm not going to take us in a circle regarding this contention, because I've understood what Chair said. I disagree with Chair's characterizations in two respects in that regard. And in fact, I think for the first time, the criticism that Chair has posited regarding the doctor has done two things with the greatest of respect. The first one is it's clarified what the actual concern is regarding the doctor's objectivity. That was the word that Chair used. And also to set up the justification as to why the independent medical exam is potentially needed because of that concern on objectivity. May I say two things in response to that, please, Chair? The first one is, I think, and I say this with all due respect, and I hope this doesn't come across as being impertinent. I think, Chair, you've actually articulated why the doctor is more necessary, not less necessary, if his objectivity is in doubt. Because if his objectivity is in doubt, which is not necessarily the same regarding the rightness or otherwise of his clinical conclusions, then it's him as the doctor offering that evidence who has to be impugned so as to demonstrate that his objectivity is justifiably in doubt, and whereafter his objectivity is justifiably in doubt, then the gateway mechanism to the medical examination is opened. So where I respectfully disagree with the Chair is I say the conflation, and I use that word respectfully, I obviously don't mean it in a personal way, but the conflation that Chair has made in positing the reason for the independent medical exam to me is an objectivity issue. But if that's an objectivity issue, an independent medical exam may come to the same conclusion that this doctor has, but that doesn't do anything in respect of his objectivity or otherwise. And what I would respectfully say, and what courts do all the time, is where an independent expert is used by one side or another as to evidential issues and legal conclusions, then you don't go and bypass that particular expert to go to the underlying individual or evidence, you impugn that expert. You impugn his objectivity, whether by demonstrating he's a liar, whether by introducing your own rebuttal expert witness, or so on. That's the ordinary mechanisms of litigation. And so the conflation that I'm respectfully contending for is...
May I just say, I'm not conflating anything. We don't have to have only one reason. The reason may one be the commission wants to be sure that there isn't a basis for not accepting what Mr. Carrim's doctor says.
Yeah.
That's one. And two, I'm then saying, the doctor appears even on factual issues to have so associated with Mr. Carrim's case, let me call it that is additional to the first reason as to why the commission would want to satisfy itself. So the original reason stays, it remains. So what you are addressing does not suddenly become the reason. Yes.
thank you, Chair. Could I be cheeky?
And sorry. And also I'm not altogether sure that I agree with you with this staggered approach on how one deals with expert evidence. I don't agree with you. You may upfront just say, I want to establish whether this should not be questioned by, at the outset, having an independent assessment. So your staggered approach, I just don't agree with. Yeah, you may respond.
Chair, I still have my second reason I'm going to come to. I'll come to that in a moment. I'm just on the objectivity leg, if I can. On the issue of the reason, I'm going to be a bit cheeky and say it can be any reason to doubt the objectivity. It doesn't matter what the reason is. My fundamental point, and I know Chair says he doesn't conflate anything, I'm going to step away from that word. My simple point then is to say that if whatever your reason is to doubt the objectivity of the expert put up, in the particular instance of a medical examination, you cannot leapfrog that evidence and that practitioner to go directly to the patient.
Why not?
Because that's going to be my second response to you, because then that takes us into the V-raise issue and whether or not you have the power to do that in the first place. So what I'm saying to you, Chair, in response to those three things you said about it could be any reason, he's associated himself with the case, and that's the basis for the concerns about and that you don't agree with the staggered approach that we're talking about. I'm willing to accept that, but I respectfully disagree with you, because not only does it leapfrog what we submit respectfully to you is the correct sequence having regard to what happens in the High Court, we also say that there's a V-raise challenge potentially to the extent to which you can make such an order and compel such examinations and proceedings.
There's no compulsion, and I'm not even sure that the virus issue that you say you are going to argue and on the basis of which you are talking leapfrogging even arises. There's no compulsion. It says, I think
it says voluntarily.
Exactly.
No.
So if he chooses not to go, nobody will force him.
Yes.
So the virus issue really does not arise at all. I know I've gone to your next point, which you have not argued, but because you've already mentioned it, nothing stops me from dealing with it. So this virus issue, from where I'm sitting, simply does not arise at all. So there's no leapfrogging at all.
Well, with all due respect, I think that it takes, and again, you would have received the highlighted transcript, which we say bears out our recollection of events from the last occasion, and I'm not going to revisit that. All I'm going to say is that takes us to the exact point that we debated there, which is, if it is truly voluntary, then no negative consequence can attach on the election of the voluntary choice. And that's where Chair and I think we agreed that we were ad idem in that regard, and then Chair moved on to, but what are the consequences if he chooses not to? And then are those subject to some or other bar? And I said to Chair, no, that's the ordinary consequence of how you determine evidence. So the point I'm making about the voluntariness of the proceeding and how it relates to the virus challenge is the degree to which the non-election to participate for the reasons in the medical report, which I would call gently a supervening medical impossibility, but be that as it may. If Chair is, and I think we're ad idem on this actually, if Chair is not going to attach any punitive consequence or coercive consequence to the election in the voluntary scenario.
Let me upfront tell you what I am, or rather what I think the Commission should do. The Commission is minded to refer Mr. Carrim for a criminal process. What the relevant authorities do in that regard is for them to decide whether it's taken to the South African Police Service for them to see whether they can lay charges, or the National Prosecuting Authority for it to see whether to prosecute. That's their decision. That is what the Commission, as we are sitting here, is minded to do.
Yes.
So that will not